Hi, good morning. How's it going?
Good, how are you?
Good. I've got a whole bunch of people logged in, so I'm just going to try and work our way through this. All right, I have somebody on the phone with the last four digits of 1611. Can you tell me your name, please?
Yes, this is Michael Scott Hardy.
Mr. Hardy. Okay. All right, and I don't see the other party signed in, but we'll take that case. This is Bergquist versus Hardy, case number 019473. The record should reflect that we have Mr. Hardy present by phone today. And we have Ms. Krause here on behalf of friend of the court. Ms. Krause, how did the friend of the court want to proceed on this case today?
The defendant was arrested and posted bond at the Crawford County Jail in the amount of $600. This is an arrears only case with a balance of $388. The friend of the court would ask that the bond to be released so a portion can be applied towards the defendant's balance, and that any additional monies would be issued back to the defendant by paper check. We would ask for him to update his address in writing so the friend of the court can ensure that he would receive any overpayment back.
Okay, Mr. Hardy, were you able to hear that?
Yeah, you said 388. I got 288.
The additional $100 could be potentially from when the bench warrant initially entered on the case.
Okay.
All right, so Mr. Hardy, the court is going to order that the bond that you posted, whatever the remaining portion is, be applied to your account. The remaining balance will be refunded to you, but as Ms. Krause indicated, we're going to need you to send your current address in writing to the friend of the court office in Gaylord so that they can send the refund check to the appropriate place.
Okay.
Do you have any questions at all, Mr. Hardy?
In writing, I just, how do I write that, I guess?
He could also contact the office to verify that the address that we have is correct, but if it is not, we would need that submitted in writing, and we can discuss that with him when he calls.
Oh, I can call.
Yes.
Yeah, just call the friend of the court office.
Okay.
All right, sounds good. Thank you. Mr. Hardy, you're free to disconnect at this time.
All right. Thank you.
Okay, we have Mr. Butts connected along with Ms. Dobbins-Speck on file number 2218954. The record should reflect that they are both connected by Zoom. Ms. Krause, as to that particular file, how did you want to proceed on that today?
The defendant was found in contempt on May 6th of this year. And if he was failed to pay his court obligation and monies towards arrears, he shall be committed to serve 21 days in the Otsego County Jail held in abeyance. The last contact from the defendant was in April to give employer information, but that information is now indicated that it is termed. He has an obligation of $395 a month, and the balance as of July 31st is $7,608.18.
Okay, Mr. Butts, why have you had no contact since April with friend of the court?
Uh-oh, something happened. I just got a support motion. I have a new job. I started at 3M events probably a week and a half ago. I started in the middle of the pay period, so I don't get paid for 3 weeks because it's bi-weekly. Um, I did just buy a $300 part for summer spar. I have the receipt. I just haven't been in. We have not been into a friend of the court to do that. And other than that, I'm doing everything I'm supposed to be doing. I just got a new job.
All right, in this file, so Miss Kraus, we've currently got, I guess there's a current finding that's already been made with regard to contempt.
Correct.
All right, so Mr. Butts, I'm gonna give you 30 days to get in contact with the friend of the court office to update them with your employment information. If you fail to do that, we've already got a sentence out there. It sounds like of 21 days that's being held in abeyance. So if you fail to do that, make that contact within the next 30 days, we're going to set this for another hearing, and it's likely that you're going to be ordered to serve that jail sentence. Okay.
No, sir, I'm gonna solve all that today. When I go after court, I'm going into work, and then I'll stop at friend of the court beforehand, and I'll let everybody know what I got to get and all that stuff.
All right. So that's that file with Miss Dobbins-Beck, and then I'd also like to address Miss Glazier is not connected here, but again, we do have Mr. Butts with regard to file number 14-15211. And Miss Kraus, can you tell me where that file is at? The one with Miss Glazier.
Yep, this file is the same circumstances. He was found in contempt on May 6th, and if he failed to pay his support obligation and money towards his arrears, the same commitment. His current monthly obligation is $386, and the balance on arrears is $22,610.12. The last payment that was received was in July in the amount of $28.57 from that prior income withholding.
Ma'am, and you do know my daughter resides with me since June 5th, right?
Have you reported that to friend of the court?
Valerie said she was gonna take care of all the paperwork for me because I didn't know. I picked her up on the last day of school, June 5th in Boyne, and she's been residing with me ever since. Her mother moved to Balu. Yeah. Beulah. I thought she would have been on here this morning with court as well, but I've had my daughter full time since June 5th, right after school start or ended. I'm sorry.
Yeah, so Mr. Butts, the friend of the court, we're not mind readers here. You need to contact us and let there's a change in circumstances. You can avoid a lot of these hearings just by staying in contact with the friend of the court office. So
No, that's fine. I was just in there a couple weeks ago and got my support motion or my thing to give to my employer. But I will take care of all that. I thought Valerie said she was gonna for sure, but it is my responsibility, not hers. And you're right, Your Honor, and I will take care of everything.
all right, so as with the previous file, we'll set this for another hearing in 30 days. And again, if you fail to do that, you know what's going to happen. So make sure that you contact the friend of the court, get everything updated on both of those files, and we'll see where we're at in 30 days.
Yes, sir.
Okay. All right, Mr. Butts, you're free to disconnect at this time.
All right, thank you.
Okay. We're on the record in Brink versus Hildebrandt. This is case number 11-14050. The record should reflect that both parties on this file are connected by Zoom. Ms. Kraus, can you tell me where this file is at this morning?
Yes, the plaintiff has a support obligation of $197 and a balance of $8,512.16. The last payment was received in February in the amount of $206.47 from a prior income withholding. There's been no contact from the plaintiff, and the friend of the court does not currently have a confirmed address since March of 2024.
That's not true. I have submitted my address.
Okay, when did you do that, Ms. Brink?
Just 2 weeks ago, probably. And the reason I haven't paid is because I can't get a job. Nowhere seems to be hiring in town, and everything that is hiring is Petoskey, Traverse area, and that's too far of a commute.
Okay, so how do you plan on meeting your support obligation?
I am getting in the middle of getting disability.
Okay, when are you gonna know about that?
August 14th, I believe, is my next hearing date for that.
Okay, what's gonna happen on August 14th?
They have to do an interview.
You what?
They have to do an interview. I'm not sure AC is going to be here to help through it.
You're breaking up. I couldn't hear what you were saying.
From when?
What is gonna happen at the August 14th date with your disability?
ACT will be here to walk me through it. I don't know, other than it's an interview.
Okay, when do you think you're gonna have a decision about whether you're gonna qualify for benefits or not?
Hopefully after that day.
Okay, Ms. Kraus, what's the friend of the court's recommendation for today?
Based on the information that she's indicated that she's applying for disability, we do have some medical documentation forms that we could mail out to her and request that she submit and possibly adjourn out 60 days.
Okay, and what about the address issue? Do we have an address for?
I do.
Right here.
Go ahead, Ms. Kraus.
I don't have an address. If she submitted it, we don't have one. The previous address has been marked bad by the post office.
That's not true. My address has not changed in over a year.
Okay,
So-
well, I'm pretty sure.
A post office issue, that's not my fault.
I'm pretty sure Ms. Kraus isn't lying about it, so you need to make sure that you update your address with the friend of the court.
Well, my
And
address hasn't changed. It's still 1336 Groveland Avenue, Gaylord, Michigan, 49735. That's where I received my mail also.
all right, Ms. Kraus, is that the address that the mail's coming back from?
Yes,
Well, I check my mail every single day. Don't know what to tell you. It's no longer my fault, though, or my problem.
All right, well, if that's the address you want us to send stuff to, that's where we're gonna send it. If you don't get it, then it will be your problem. So you're gonna have to figure out that part of it.
Mail. I check the mail every day.
Good. Okay.
So there's no possibility that it's stacked up in the mailbox somewhere. Unlike how the Hildebrands check their mail.
Okay, good. Well, we didn't have any problems then, so that's good. So we'll send the information to that address. I'm gonna give you 30 days to fill out that information for friend of the court and return that. We're gonna set this for another hearing in 30 days. If you fail to do that within that period of time, then the court's gonna proceed with contempt proceedings, which could include incarceration. And Ms. Kraus, would this be a first finding of contempt or a second or subsequent?
I believe it would be first finding.
Okay, so you may be subject to up to 45 days in jail, Ms. Brink, if you don't fill out those papers and return those to front of the court in the next 30 days, okay?
Talking about, I don't know of any papers. I check my mail every day. The last
Yeah,
paper that I
we're
had
gonna
to
send,
get today, I don't
we're gonna
see
send,
in court.
we're going to send them to you at the address you gave us. You'll have 30 days to fill those out and return them to the front of the court. If you don't, we're going to proceed with contempt and you may be subject to 45 days.
Get that.
I don't know. That's your problem, not ours. You gave us the address. We're going to send it to that address. You're
I
not
don't-
getting your.
2 weeks, then I will call the court, have them resend it.
Okay. It's going to be your obligation to make sure that you get that taken care of. Okay.
And what kind of stuff is it that I'm supposed to be filling out?
It's going to be forms related to your application for disability benefits.
How does my disability have any effect on my child support?
Well, you just told me that you plan to meet your child support obligation by receiving disability benefits and using that to pay for it. So that's how it relates.
Okay, and what happens if they deny me again for a disability, which they've already done 4 times? The likelihood of them not.
You're gonna have to find another way to pay for your child support obligation.
Well, there is no other way. I've tried all the ways. This was my last option.
Well, I don't know what to tell you. You're gonna have to find a way.
Don't tell you either, sir. I hope you have a great day.
Okay. All right, so Ms. Kraus, if you can set that hearing for 30 days, please.
Will do.
Mr. Hildebrand, did you have any questions at all?
I don't have any questions, but I also don't understand how she's not paying her child support when she's been to the bars multiple times and she can figure out the gas to get, oh, dang near to Elmira, to my parents' house where she's not welcomed a few times this month. And it's just, I just can't fathom how she's doing what she's doing. And that's about it.
Okay, I understand. And like I've indicated, if she fails to either pay support or comply with filling out these forms, then again, the court's going to look at imposing jail time.
Yes, sir.
Go from there. Okay. All right. Thank you. You're free to disconnect at this time.
All righty. Thank you.
All right, Mr. Mogenberg, I need you to unmute and turn your camera on, please. Okay. We have Mr. Mogenberg connected in Fisher versus Mogenberg, case number 1817144. And Ms. Kraus, can you tell me the status of that file today?
Yes, the defendant posted bond on June 26th, so we would request that the bond be released to the friend of the court and applied to the arrears. After the payment is applied, he would have a remaining balance of $324.50. The friend of the court would request the defendant pay the balance off timely because there has been a change in custody with an order that entered on June 27th. And if he was to do that, we would dismiss the matter, but ask that it be adjourned in front of referee legal on October 16th.
Okay, Mr. Mogenberg, is that something that you can take care of?
I should be able to. I had a knee injury that I'm supposed to have surgery on, but it hasn't. I should be able to. I'm not going to make any excuses. I should be able to.
Okay. All right, so we'll go forward as.
I do need that date again, October something.
October 16th.
Okay. And what time was that?
It would be at 9 a.m. We would send a notice out to your
Okay.
address.
Just making sure. Thank you.
Yeah, you're welcome.
Okay, so we'll proceed as you've indicated, Ms. Kraus. Any other questions, Mr. Mogenberg?
I don't know if it's something that you can do or not because it's with a different judge, but these seem to be on. I have another hearing on the 8th for my other two kids, and they just seem to be on the different date every time, and I think that's what's been getting me in trouble is the dates being separate. Is there a way to get the dates like kind of put together for when I have hearings, or is that something that really can't be done right now?
Yeah, I think that's probably because your other file is in front of Judge Hunter. Yeah. That's probably not something that we're going to be able to adjust, unfortunately.
All right, no problem. Thank you, sir.
Okay, all right. Thank you. You're free to disconnect at this time.
Thank you.
Okay, we'll go on the record in Radke versus Brown, case number 2319235. We have the plaintiff Jacoby Radke connected by Zoom. I do not see Mr. Brown in the Zoom waiting room. But Ms. Kraus, can you tell me the status of this file today?
Yes, this hearing was adjourned from July 10th in front of referee Kyle Legal. It was recommended that he was to make a purge payment of $2,000 before today to not appear, but we have received information from the state that he's residing in, a confirmed address. So friend of the court would actually request to dismiss this in order to register for enforcement in his state.
Okay, Ms. Radke, did you have any questions about that?
But that was already in works, but no, I don't have any further comments.
Okay. All right, thank you. So Ms. Kraus will proceed as you've indicated on this file, and Ms. Radke, you're free to disconnect at this time.
Thank you, Your Honor.
Susie, can you do me a favor? We have an individual on the front of the court docket, Daniel Coburn. He's lodged at the Otsego jail. I'm sure that Jen notified them, but they haven't connected yet. Would you mind? Jen's out today. Would you mind?
Absolutely.
Calling?
Yep.
Oh,
yep. Absolutely.
Thank you. Okay, we have Mr. Hassel connected, and this is case number 1716873. And Ms. Kraus, can you tell me the status of this file, Hassel versus Bergman?
Yes, this hearing was adjourned from July 1st for the defendant to provide updated employment situations. And if he's unemployed, he would submit the appropriate job searches and additional information requested by the friend of the court. And the defendant shall comply with any request made by the friend of the court. Since the hearing, the defendant did submit and file the motion for support. The hearing is set in front of referee Kyle Legal on August 28th. He was also instructed to submit 15 weekly job searches to the friend of the court commencing on July 15th. There's been no contact since the defendant's release at the court to the friend of the court on July 2nd. His obligation is $883, and he has a balance of $21,800 $891.06. The last payment was bond and an additional $100 payment in July, which equaled $600.
Okay, and you said that hearing is set in front of referee later this month in August?
August 28th.
Okay. All right, in light of that, what I'd like to do today is just adjourn this out for 30 days so that that hearing can be held in front of the referee. And then if we need to proceed, we can. But I'd like to have that resolved before we go any further with any action on the part of the court. Mr. Hassel, do you have any objection to that? You're muted, Mr. Hassel.
Can you hear me?
Yeah, yep. Do you have any objection to going forward with that hearing in August, later this month?
I have an attorney, no objections.
Okay. Okay, so Ms. Kraus, if you can set this for September, and then if we don't end up needing it based on what happens at the referee hearing, and we can just take it down.
Okay.
Okay, thank you, Mr. Hassel. Just make sure that you proceed with that hearing at the end of the month in front of the referee, and you're free to disconnect at this time.
I have one more thing I want to put on the record before we leave. And
Sure.
that's, they're saying that I need to submit 15 job things a week. And I don't have any internet at my house right now. And I don't have good signal because we have Operation Desert or Grayling Storm going on right now. So the phone signal at my house is absolutely horrible. And I just don't have the gas to be driving all over to be submitting these 15 job apps. So how am I supposed to submit these job apps when I don't have internet at my house and my phone doesn't currently have signal while all the troops are here? And I'm a stay-at-home dad, so it's hard for me just to drive around in a Dodge Ram and put job apps in all over. Like,
I don't know, Mr. Hassel. Got to figure it out.
all right.
Get creative, you know, go to the library, do them all in one day at the library, you know, I don't
Okay.
know.
All right.
Okay, thank you. You're free to disconnect at this time. All right, Mr. Coburn, are you able to hear me okay?
Yes, Your Honor.
Okay, and just to confirm, you are Daniel Coburn, is that correct?
Yes, Your Honor.
Okay, this is Wood versus Coburn, case number 1515790. Mr. Coburn is appearing today by Zoom from the Otsego County Jail. Mr. Coburn was, I believe, arrested on a bench warrant in this file last week. He's been lodged since that time. Ms. Kraus, can you tell me the status of this case today?
Yes, the defendant has a support obligation of $259 and a balance of $997.97. We've not had any contact with the defendant since February, when at that time we actually discussed the potential stipulation, but nothing was done at that time. Friend of the court would not be opposed to bond reduction and would request the defendant provide updated employment situations. And if he's unemployed, he would need to submit appropriate job searches and any other additional information requested. We'd also request that this be adjourned in front of referee Kyle Legal on October 16th. So that way, if he has any other court proceedings, those could potentially be handled before that.
Okay, Mr. Coburn, are you being held in a different case as well? Like, do you have multiple bond provisions?
Yes, Your Honor.
Okay. If the court lowers the bond in this file, are you going to be able to post bond in your other cases? Do you know?
That I am unsure. I know I'm here for at least 90 days on a sentence from another case, and I'm waiting for another one to come about.
Okay. All right. So Ms. Kraus, I think did you say we currently have a hearing date set in October in front of the referee?
We could set it potentially in front of the referee in October.
Okay, so let's do that. I'm gonna reduce this to a PR bond, because it sounds like Mr. Coburn is not gonna be released based on his other matters. And then we can have it set for that hearing in October. And Ms. Kraus, if you can put in that order that if he is released prior to that October date, if you can put those stipulations in that you mentioned regarding updating employment information or submitting job searches if he is released.
Okay.
All right, Mr. Coburn, do you have any questions at all? So we're going to reduce this to a PR bond, so you won't be held on, in jail on this file. I don't know what'll happen with your other matters.
All right, I appreciate it, Your Honor. And just the one question.
Yeah.
With the stipulations, if I do get released early, would I just report to FOC to get that information?
Yes, yep, and we're going to give you a written order there at the jail that explains what we've discussed here today.
All righty.
But yeah, if you are released, you do need to contact front of the court right away so that you're not rearrested on another bench warrant.
All righty.
Okay.
Understood.
All right, thank you. That's all for today, and we're going to disconnect at this time.
All right, thank you.
Okay, 1 second. It looks like we have 2 other files on my docket. I don't have anybody else left in the waiting room relating to those 2 files. So there's Fritz versus Galt, case number 1013413. Neither side has appeared on that file today. Ms. Kraus, what's the status of that one?
Let me just grab the right one. Bear with me. On June 3rd, the defendant failed to appear before Your Honor, but had complied with what was ordered. Therefore, the show cause was set before the referee on July 10th. And the friend of the court was directed to reset this matter before Your Honor if he failed to appear before the referee so the issue of contempt could be addressed. He did fail to appear.
Okay, if you can prepare a bench warrant then for Mr. Galt for his failure to appear on July 10th and today, and we'll proceed further on that case once he's arrested and brought before the court.
Okay.
The last one I had is Singer versus Bowen, case number 1716760. For the record, neither side has appeared on that file today either. Can you tell me the status on that one?
Yes, it does appear that the defendant posted bond on July 11th. We would request that the bond be applied to his balance. A portion of it be applied towards his balance, and then any additional monies would be issued back to the defendant in a paper check. The case is currently charging at $131 a month, and the balance remaining right now is $627. We would actually request that this could potentially be adjourned out to in front of the referee on September 18th because it is continually charging and there was requested medical documentation that hasn't been submitted.
Okay, so the court will order that any bond be applied to the account. The court will order that this matter be set for hearing as you've indicated in front of the referee in September. And court won't take any further action today.
Thank you.
Any other matters that you had that I missed?
No, I don't have any that I'm aware of.
Okay, great. Thank you. Thanks for your help this morning.
Thank you.
Okay, Mr. Blumberg, are you able to hear me okay?
Yes, I am, Judge. Thank you.
Okay, and do you have your client with you there?
I do.
Okay, great. And it looks like Mr. Turner is connecting.
I'm here.
Okay, we have Mr. Turner connected. So we're on the record now in Turner versus Turner. This is case number 2419678. Both parties are connected by Zoom along with Ms. Turner's counsel, Mr. Blumberg. This is set for a status conference today. I did see that the parties have a hearing set for later this month in front of the referee regarding custody and parenting time issues. But in terms of property division, Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at with regard to that part of it?
Judge, actually, as it relates to custody, that August 19th hearing may not be necessary. I understand the parties have come to an agreement. If that's confirmed, then obviously we won't need that hearing. The property issues are not resolved at this point. Mr. Turner's only recently started contributing on a regular basis to support the family. There is an order in the court that requires maintenance of the status quo. We're simply hoping that he'll continue to make the payments as he's represented to his wife that will be made. Mr. Turner has his own business. There are some assets that need to be appraised. I'm still hopeful that we can resolve this without mediation, but perhaps it would be prudent if the court ordered us to community mediation.
Okay. Mr. Turner, community mediation, it's a process where you meet with an independent third party along with your Ms. Turner and Mr. Blumberg. You're not required to, agree to anything, but that independent third party mediator tries to facilitate agreements between both of you to help move things along. Do you have any objection to participating in that?
No, I don't have any objection. Actually, because it's a current AP, to discuss any of the details with her anyway. So mediation sounds like it'd be a course of action.
Okay. Mr. Blumberg, did you want any time prior to mediation?
I would hope that we could get it scheduled within the next 45 days and maybe just some very limited discovery.
Okay. So the court will order that the mediation occur within the next 60 days and we'll refer it out to the community mediation. So Mr. Turner, they'll be in touch with you to set up a date, time that works for you, as well as Ms. Turner. And they've been doing those remotely by Zoom. So I expect it'll be, process will occur that way. Mr. Blumberg, anything else we need to address on this file today?
I don't think so, Judge. Thank you.
Mr. Turner, did you have any questions at all?
No, Your Honor.
Okay, thank you. All parties on this file are free to disconnect. Mr. Blumberg, I'm just going to put you in the waiting room for a minute until I call your next case.
Very good. Thank you.
Thank you.
Have a good day.
Thanks, you too.
Okay, it looks like we have all the parties connected on Goodwin versus Goodwin. That is file number 2419692. Oh, there she is. Okay. If I could just have both counsel unmute and put your appearances on the record, please.
Thank you, Miranda Bailey Quick on behalf of Jenna Lee Goodwin.
Good morning, Judge Matt Cross on behalf of Jeremy Goodwin.
Okay, good morning. I think this is our first status conference in this case. Ms. Bailey Quick, on behalf of plaintiff, can you kind of update me on where things are at from your side?
Thank you. Last week we had our friend of the court hearing, and just so that the court's aware, the party's youngest child does turn 18 on August 22nd. And so at that time, the youngest child will be emancipated, and this case can be converted to a DO case. And so I've not had this in all of my years of practice occur. And so I guess I was just looking for a little bit of direction from the court, whether or not you would like me to motion to have the case amended. The front of the court is going to still proceed forward because there is state assistance with child support recommendation for the period of time from the time of filing until the child's 18th birthday. But frankly, custody and parenting time is going to be moot. But I agree that that's appropriate. But as far as the waiting period, I'm just not sure if the court's still going to want to have a 6-month waiting period. At that point, I think the case would be ripe for entry of a judgment, but we don't have any resolution yet. The friend of the court did refer the case to mediation. I know mediation did contact my client. I have not received a call yet to schedule a mediation. I did just receive appearance of counsel, and so perhaps we can try and facilitate that and try and move towards getting that scheduled and moving towards a resolution.
Okay, thank you. Mr. Cross?
I don't really have anything to add, Judge. Apparently there was I guess only to add that there was a little bit of a mix-up with the scheduling of the front of the court hearing. Mr. Goodwin didn't receive notice of that, so he wasn't present. I guess we'll have to deal with that issue later, but he is going for his SMILE assessment, I believe tomorrow, no, today. So I did enter my appearance on July 31st, and we are going to take this to mediation. I'm hopeful that we can resolve all the issues that are remaining at mediation.
Okay. Tell me again, when does the youngest child turn 18?
The 22nd of this month.
Okay. So I think in terms of addressing that issue, if counsel wants to stipulate, I think you could submit a stipulation in order amending the caption to a DO as opposed to DM. We definitely need to do that as a part of the record. And then at that point, I think we can, in terms of the timing, I don't think the court needs to impose that 6-month waiting period. I think we could enter the judgment, at any time after the 60-day period, once it's amended to a DO caption. So I guess I'll just ask counsel to get together and submit that order and stipulation amending the caption to DO. I'm gonna just put in terms of scheduling, discovery to remain open, mediation to occur within the next 60 days. And then I'll set this for another status conference, which if there is an agreement at that point, we can use for entering proofs and finalizing the divorce. Either do you have an objection to that 60-day time frame for mediation?
No, Your Honor.
No, Your Honor, that's fine.
Okay. All right, Ms. Bailey Quick, on behalf of plaintiff, anything else that I can address for your side today?
No, Your Honor, I think that satisfies it.
Okay, Mr. Cross?
No, Your Honor, thank you.
Okay, I'll put what we've discussed today into an order, get that out to the parties along with the notice of date and time of that next status conference, and all parties on this file are free to disconnect at this time.
Thank you, Judge.
Thank you, Your Honor.
Okay, we're on the record now in Tomaski versus Tomaski, case number 2319198. If I could just have both counsel put your appearances on.
Good morning again, Judge Elliot Blumberg on behalf of the plaintiff, Tomaski.
Good morning, Your Honor. Mark Dundon appearing on behalf of defendant Dan Tomaski.
Okay, we're on the record for a status conference today. I'm not sure how we need to proceed. I guess I thought, I don't know. I'm not sure what I thought. Mr. Blumberg, can you tell me where we're at with this case?
I can tell you what you thought, Judge, and that is the parties have all signed a consent judgment of divorce, which has been approved by the front of the court, and we will have that over to you by the end of the day for your signature.
Okay, do we need to take proofs or have we already done that?
I think we've already done that.
Okay, that's what I thought. All right, Mr. Dundon?
No, that's correct, Your Honor. I believe it's good to go.
Okay, very good. I don't have anything further on that file. Mr. Dundon, you're free to disconnect.
Thank you.
Mr. Roll, I'm going to bring Ms. Duke-McCoy in now on the next case.
Thank you, Your Honor.
How much wine?
To remove his goods.
Oh, I don't know. I'll find out.
Okay, we have everybody connected on Hill versus Colano. This is case number 11-14120. If I could just have both counsel put your appearances on in that file, please.
Jennifer Dusman-Coy on behalf of Tyler Colano, who is present with me in my office, Your Honor.
Good morning again, Judge Elliot Blumberg on behalf of Kendra Clark, who is coming in the waiting room. She'll be right here in a second.
All right, so Ms. Dukes-McCoy, you've objected to a referee's recommended order and you're requesting a de novo hearing before the court. Is that correct?
That is correct, Your Honor.
Okay. So how much time do you think, I mean, I know there were 3 previous hearings in this matter, and you know, my usual practice is to not have parties repeat testimony that was already heard in front of the referee. So the court will review, you know, the transcripts from the hearings and take that information into account. The hearing before this court, from an evidentiary standpoint, I think would involve any testimony that there wasn't time for during the referee hearings, and testimony relating to any new developments that have occurred since the last referee hearing. So with all of that in mind, Ms. Dukes-McCoy, how much time do you think the court would need to set aside for a hearing?
Considering that there have been some new developments that I think we would need some time to take testimony on and to supplement that record that we had from the referee. I was going to ask the court for a maximum of 1 day, given that we did end up taking quite a bit of time with the referee. I think just because the parties tend to take a little bit of time, but I think 1 day would be sufficient.
Okay, Mr. Blumberg?
Judge, I just want to be clear that the objections that the court will hear are limited to those specific objections made based on the findings of the referee. That is, any of the factors that they find the error, the referee erred on, as opposed to retrying the whole case again. Because my review of the objection to the referee's findings was basically they've objected to everything. I mean, and I don't know how we're going to do that. If that's the case, and it took us 3 days to try it the first time, I don't know how we're going to do it in a single day.
Well, like I said, I'm not going to take all that testimony over again. I'm going to read the transcripts from the referee hearing and consider that as part of the evidentiary record. So the purpose of this hearing would just be to supplement that. I mean, in terms of the objections, it was a very thorough brief that Ms. Dukes-McCoy filed. And I think she did set forth in considerable detail the objections that they had. And I think she's entitled to, you know, under the court rules to object. as she has. So the court will make rulings as to all of her objections. But from an evidentiary standpoint, I mean, I agree, we're not going to retry everything that was heard in front of the referee.
So in terms of witnesses that would testify at a de novo hearing, historically, the position of the court has been if they didn't testify at the referee level and they didn't make a showing that somebody was unavailable, then that witness would not be allowed to testify at a de novo hearing?
Unless they had something, to add to events that have taken place since the hearing, or unless either party, whoever's calling the witness could show that they would have called that witness, but the referee didn't allow it because of time constraints or,
Sure.
So, but yeah, I would not permit the parties to just, bring in witnesses to testify to things that could have been testified to at the referee hearing, but counsel chose not to call those witnesses at that time, I guess.
So do we need to file a witness list then, Judge, as to who is going to be called?
Yeah, typically I would have the parties submit or exchange their witness list 7 days prior to the hearing date.
Very good.
And then, Mr. Blumberg, I'm assuming that you would file you may have already done it, and I just didn't see a judge's copy yet, but a response to Ms. Buttes-McCoy's brief.
Yes.
Okay. Given the limitations that the court has mentioned, do you believe that 1 day would be sufficient?
I'm a little concerned that it might not be. I just, we can try to certainly push it along. I mean, we'll try to do it in a day, Judge. I don't know.
I mean, I guess my feeling is, and I haven't looked at the transcripts yet, so I don't know how long the hearings were, but if we've already had 3 hearings before the referee, I gotta believe that the parties are getting near the bottom of what they can present in terms of, evidence here, other than new things that have occurred, since the referee hearing. But 4 separate hearing dates, I think, should be sufficient in just about any case for the court to have enough evidence to make determinations. So
I guess I'm sorry, I didn't mean to interrupt.
And I'm hesitant to schedule it for more than 1 day, I guess is what I'm saying.
The minor child testified at the referee hearing. So I don't know if the court would need to interview you, because one of the preference of the child, I believe, was objected to by the other side. Would the court feel it would be appropriate to interview her even though she testified at the previous hearing?
Yeah, I do not have the minor children actually testify, but I do interview the minor children. So the order scheduling the hearing will indicate that the child should be available, 15 minutes prior to the start of the hearing, so the court can have a in-chambers interview regarding that factor, so that the notice of hearing will specify that.
Okay. Thank you.
Okay. So the court will set this for a 1 day hearing. Parties will be directed to exchange witness lists 7 days prior to the hearing. Again, the notice of hearing will indicate that the minor child is to be available for the court to interview in camera 15 minutes prior to the start of the hearing. And the court will send out that notice of the date and time. Ms. Buttes-McCoy, anything further from your side that we can address today?
Not for today, Your Honor. Thank you.
Mr. Blumberg?
No, thank you.
Okay. All right, thank you. All parties on this file are free to disconnect at this time.
Thank you.
Okay. Mr. Rolla, are you able to hear me okay?
Yes, I am. Good morning, Your Honor.
Okay, good morning. And we have Ms. Schultz present. And Mr. Rolla, did you submit a default judgment by email today or?
Yes, Judge.
Okay. I didn't have a chance to print it out yet, but I did see in my email that one was sent. So Mr. Rolla is here. This is Schultz versus Bennett, case number 2419619. Mr. Rolla is here on behalf of the state. Ms. Schultz is here as the plaintiff. This is set for a default judgment today. Mr. Rolla, is there anything for the record that you wanted to state today?
Yes, briefly, Judge. This is a third-party court-ordered guardianship case, so it's a situation where support cannot be waived. And it indicates that in the paperwork, but I just wanted that to be clear for the record. It's not one where there's a situation waiver.
I'm sorry, you were kind of breaking up there.
I didn't know if that was on my end or your end, Judge. I'll repeat that then. My apologies. This is a I don't know if somebody's got other electronics going on or what.
I don't think so.
I don't.
Okay. We'll just do the best that we can.
In any case, Your Honor, it's still doing it. I don't know why the interference is going on, but this is a third-party court-ordered guardianship case, so it's not a situation when for the person receiving the funds can waive it. It's not a waivable case.
Okay. And the judgment today is going to provide for payment of support by Hillary Bennett. Is that correct?
That's correct, Your Honor.
Okay. All right. 1 second, because I see Miss Bennett is connecting right now, so bring her in. All right, it looks like she's having connection problems, so I'm going to note for the record that Ms. Bennett has tried to connect today, but has been unable to. So Ms. Schultz, can you unmute real quick, please?
Yes,
Thank
sir.
you. You're Jessica Schultz, is that correct?
That's correct.
Okay, and you have guardianship over the minor child in this case?
Correct, and I've had it since August or September of last year through the courts.
Okay, and in your role as the guardian in this case, do you agree that entry of this order requiring payment of support is in the child's best interest?
Yes.
Thank you. The court notes for the record that Ms. Bennett was properly served with the summons and complaint in this case, that she did fail to answer the complaint at any point as required under the court rules. She was properly defaulted. She has tried to appear today, as I indicated, but it appears that she's having technical difficulties. But regardless, because of the default, she would not be in a position to contest the order. So the court will sign that order with today's date. Ms. Schultz, if you have further questions, you can contact Mr. Rolla at his office. He'll be happy to help, I'm sure. Mr. Rolla, anything further that we need to record today?
On behalf of the state, thank you, Judge.
All right,
Thank you for your time, guys.
And Ms. Schultz, you're free to disconnect at this time, as are you, Mr. Rolla.
All right, thank you, Judge. Thank you, ma'am.
Okay. Thank you so much.
Our next hearing is set for 10:15. We'll take a short recess. until that time. Okay, looks like we've got everybody connected. We'll go on the record in Casper versus Casper. This is case number 2419733. If I could have both counsel put your appearances on, please.
Good morning, Your Honor. Angel Anderson on behalf of plaintiff Rebecca Casper.
Good morning again, Judge Elliot Blumberg on behalf of the defendant Matthew Casper, who's appearing via Zoom in my office.
Okay, and the record should reflect Ms. Casper is also present. We've got this set for scheduling conference in this case today, and then Mr. Blumberg, you filed an objection to an ex parte order that was entered actually by Judge Boudet on my behalf at the beginning of the case. So I guess, Mr. Blumberg, if you wanted to go forward with your argument on the objection first.
Judge, I wasn't aware that was going to be heard today.
Oh,
I mean, I think
okay.
we did that. The court's ordered that it was going to be scheduled for a hearing.
Maybe I may be wrong.
I mean, I have it right here.
Okay. Has the court already set a separate date for an evidentiary hearing on your objection?
No, it has not.
Okay, so we need to do that then.
Right.
Okay. How much time do you think we would need for that evidentiary hearing?
I'm thinking just an hour would be sufficient.
Okay. All right, so the court will set that. In terms of other dates going forward, Ms. Anderson, on behalf of plaintiff, in terms of division of marital assets and debts, can you tell me where things are at from your standpoint and what you would like to see for scheduling?
Your Honor, I think we need a period of discovery here. Obviously, with the parties not being able to have any contact, that makes things a little more difficult. And I've not, to date, Mr. Bloomberg and I have not had any discussions around it. So I think we need a period of discovery. There are obviously marital assets, and with the parties being unable to communicate. Possibly mediation. I think we should leave that as an option. I don't know that we'll need it, but.
All right. Is 90 days enough time for discovery from your standpoint, Ms. Anderson?
From our standpoint, it would be, Your Honor.
Mr. Blumberg, any objection to that time frame?
No, but assuming if we need additional time, we could do that by stipulation.
Yes, definitely.
Absolutely.
That would be fine.
And then if the court sets a deadline for mediation to occur just at some point within that 90 days, do either of you have an objection to that?
No, that would be fine.
And then the court will get a date, send that out to the parties for the hearing on the objection. Mr. Blumberg, any other scheduling for your side?
No, Judge, I mean, the matter, the custody and parenting time issues are going to be resolved initially through the referee. I think we have a date at the end of August for that.
Okay. All right, Ms. Anderson, any other dates that I can address for your side today?
Well, there are not, Your Honor. I don't understand what happened with today. I did get notice. I'm not certain, but that's fine to adjourn this to a separate.
All right, thank you. I'll put what we've discussed today into an order. The court will get that out to the parties along with the date for that evidentiary hearing, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Okay, Miss Bailey Quick, are you able to hear me okay?
I can.
Okay, how does your client pronounce her last name?
Nickel.
Okay, so we're on the record in Nickel versus Nickel, case number 2419729. Miss Bailey Quick is here on behalf of the plaintiff, who's also connected by Zoom. And Mr. Nickel, are you there?
Yes, I am.
Okay, so we have everybody connected. Again, this is case number 2419729. We're on the record here today for a scheduling conference. Ms. Bailey Quick, on behalf of plaintiff, can you tell me how you would like to proceed and what kind of scheduling you'd like to request going forward?
Yes, the parties have been communicating. I would just ask the court to set this for, or to refer the matter to mediation, to be completed within 60 days. And perhaps set it for a status conference at that time, or alternatively, a pro-con date.
Okay, Mr. Nickel, do you know what mediation is? Have you been through that process before?
It's a little foggy, I guess. Can you hear me okay?
I can, yeah. So mediation, it's a process where you and Ms. Nickel will sit down, or it'll be virtual by Zoom, but you'll meet with a neutral third party who's trained in trying to resolve disputes. And that person will try to facilitate agreements between you and Ms. Nickel in terms of division of any marital assets or debts. You're not required to reach an agreement. You know, nobody's going to force either side into that, but that neutral third party mediator does try to facilitate agreements between the both of you. So if you have any objection to participating in that?
No, that sounds fine.
Okay. So the court will refer this then to community mediation. They'll be in touch with both sides to schedule a date and time that works for everybody. Then the court will set this for a status conference at about 60 days. If the parties have been able to reach agreements, then we can use that date to finalize the divorce. And if not, we can discuss further scheduling. Ms. Bailey Quick, anything further that you wanted to address today?
No, Your Honor, I appreciate it.
Mr. Nickel, did you have any questions at all?
So I'll get notification by mail or by phone, or how will the notification come for the?
I think they'll probably try to contact you by phone or mail. It could be either way.
Okay.
Okay,
Yeah.
so just make sure you follow up with that when you are contacted. And the court will also send out a notice of the date and time of the next hearing. All parties are free to disconnect on this case.
Thank you.
Thank you.
Okay, looks like we have both counsel connected, so we'll go on the record in Trevor versus Northern Food Group, Ansneck and Bunnell, case number 2319554. If I can have you both put your appearances on, starting with plaintiff, please.
Good afternoon, or good morning, Judge. Elliot Blumberg on behalf of Mr. Trevor, who's appearing from my office Zoom.
Good morning, Your Honor. Paul Slough on behalf of the defendants.
Okay, thank you. We're on the record here today for a status conference in this case. I know Mr. Blumberg, in light of the court's prior ruling, did file an amended complaint. Mr. Slough, I believe, also filed a counterclaim. So in terms of scheduling going forward, Mr. Blumberg, is there more discovery that needs to be done from your standpoint?
Yes, there is, Judge. The operating agreement specifically allowed for my client to be able to review the actual books of the company. We've not been provided those. We've been provided select handouts. So part of the evaluation process is something that's ongoing. And as far as the counter complaint, there needs to be discovery done on both our claims and Plough's claim.
Okay, how much time do you think you need for discovery?
Well, I think certainly the accounting aspect is going to take probably at least 60 days.
Okay. All right, thank you. Mr. Slough?
Yeah, that's fair, Judge. Mr. Blumberg's, I think, fairly outlined the issues. The counterclaim is really just a declaratory judgment request consistent with the order on the summary judgment motion, summary disposition motion. So I don't know that we need a lot of discovery on the counterclaim, but again, some discovery will be required to value the interest of Mr. Trevor and the company.
Okay. Mr. Blumberg, is this a case, you know, I mean, I'm obviously through the motion practice, I'm kind of aware of the claims here. Is this a case where you think mediation is appropriate, or how do you want to proceed in that regard?
Yeah, I think that it might be productive. I don't know if Mr. Slough's clients feel that way, but we're always open to mediation.
Mr. Slough, any objection?
We don't have any objection to.
Okay. So how about this? If the court sets aside 90 days for any remaining discovery and then sets 90 days as a mediation cutoff, do either of you object to that time frame?
No, that'd be fine.
That's just fine. Thank you.
Okay. And then the court will set this for another status conference at about that 90-day mark. If the parties are able to mediate and settle the case, then we can take that date down. If not, then we can see where things are at and set more scheduling at that time. Any objection to that process, Mr. Blumberg?
No, Judge, that's fine.
Mr. Slough, any objection?
That's just fine. Thank you.
Okay. Do you believe that the two of you will be able to agree on a mediator in this case?
I'm pretty confident we will.
Yeah.
Okay. All right. Great. So the court will send out that notice of the next status conference. I'll also put what we've discussed here today into a status conference order and send that out. And both sides are free to disconnect. Thank you.
Good luck tomorrow, Mr. Slough.
Thank you, sir.
Okay.
If you would send me a couple names of mediators, and then I'll get
Sure.
a letter to the mediator clerk. Perfect.
Sounds good.
Thank you, everyone.
Bye-bye.
William, Kevin?
Good morning, Your Honor.
All right, let's see. Still got some of the lawyers connecting here. Okay, Mr. Carey. All right, Mr. Ryman, are you there? Mr. Ryman, are you there? All right, let me start with counsel. Mr. Couch, are you able to hear me okay?
I am, Your Honor. Thank you. Good morning.
All right, good morning. Mr. Carey, are you able to hear me?
Yes, sir. Good morning. Good morning, Mr. Couch.
Good morning.
Mr. Ryman, are you there? I see Mr. Ryman's connected. He's got his microphone off, but or turned on, but his camera's not on and it's not responding. Okay, I just got a message from Mr. Ryman. He's trying to connect his audio, so if counsel can just hold on for just a minute.
Thank you.
Good morning, Your Honor. Good morning, David.
Good morning.
Okay, Mr. Ryman, are you able to hear me all right? All right, we'll go on the record. This is Ryman versus Johnston and Prather. This is case number 2319394. We have all the parties and counsel connected. I think there was a little bit of confusion, Mr. Carey. The court did originally have a status conference set for today, but because we moved the dates out, the court renoticed that. So I think the issue that we're here on today is Mr. Couch, your motion regarding the depositions. Is that correct?
That's correct, Your Honor. Yes.
Okay.
So I don't have a position or as a dog in that fight, as they say. I only signed on because I thought maybe we'd have the status conference, but if the court has rescheduled that, and if the court and counsel have no objection, I'll bow out of this as gracefully as possible.
Yeah, I certainly have no objection to that.
All right. Thank you, guys.
Okay. So Mr. Couch, I did have a chance to review your motion in brief as well as Mr. Ryman's response. Is there anything that you wanted to state for the record here?
No, Your Honor, but I would like to just make a very brief record if I could.
Sure.
This is Defendant Johnston's motion for protective order. And I'm happy to report to the court that the plaintiff's deposition did go forward on July the 17th in person. And Mr. Riemann and I had an opportunity to meet, shake hands, and establish a rapport. And so I think discovery is moving along well in that regard. I'm happy to report that to the court. But as I noted in our motion, that on the heels of the last motion hearing, Mr. Riemann scheduled the depositions of the Johnston defendants on 2 dates that I told him posed a conflict for my clients. I gave him alternate dates. Instead of rescheduling them, he indicated he intended to go forward. I felt that this motion for protective order was necessary because I didn't want the plaintiff to set depositions, know that the defendants can't appear, and then when they don't appear, ask the court for costs or sanctions. I provided him with alternate dates. I gave him a broad range between July 29th and August 29th. And I specifically suggested the dates of August 21 through August 23rd. MCR 2.302C allows the court to enter a protective order which specifies the date, time, and location of discovery, in this case, a deposition, And, I'm not asking for any costs or sanctions against Mr. Raymond. I'm just asking for the court's guidance and assistance in setting a date for my client's depositions that works well for everyone.
Thank you. Mr. Riemann, was there anything that you wanted to state in addition to your written response? Are you there, Mr. Riemann?
Your Honor, I believe he may be typing his response to the court.
Yeah, so Mr. Riemann, I mean, we need to make a record. So I see you are putting chat messages in here that you can hear us, but we're going to need you to be able to verbally participate. So I don't know if you want to try calling in as opposed to using video. I'm not sure how you want to proceed. So you can call in using Zoom. So
Judge, can you hear me now?
yes, I can hear you. Okay, good.
I logged in on another computer, but it's making an echo on my original computer, so I don't know what's going on there. Can you hear me now?
I can, yep. So if you'd like to, do you need anybody to repeat anything that's gone on? Or
No,
were you able
thank
to
you,
hear?
Your Honor. I was able to hear everything.
Okay, great. So is there any response that you wanted to provide?
Yes, Your Honor. I have, as I noted in my response, I've been waiting on some reports from some outside agencies that I don't really have any control of, and I'm pretty close to gathering all the information I have to bring the motion, which would include a request for sanctions for the latest breach of discovery by failing to show up for the depositions for the Johnstons. But Your Honor, what we can address at this time is just, let's just start very basic again. Habitually, the defense has failed to follow even the very minimal requirements of the court rules. So I set their depositions originally after requesting for about 6 months dates. I finally got dates in agreement in May, and I set those depositions with counsel's agreement, Mr. Couch and everybody. And the day before the depositions, Mr. Couch had a secretary send an email that they were canceling all the deps. So I set them in June after sending around an email for requesting additional dates and getting no response from anyone, including Mr. Couch. The next thing that happened after I sent a request suggesting dates and requesting dates is Mr. Couch unilaterally set my deposition in July on one of the dates I suggested. So I tried, and these emails have been attached to the court on the previous response, tried in several emails to everybody to get them to agree to do the depositions on the same date or on the other dates I suggested at the same location that my dep was set. And those requests were refused. So I set the Johnston's depositions under the court rules, the court rule for setting depositions, and Mr. and Mrs. Johnston didn't show up. So then I set their depositions, this latest round, Your Honor, on a date, each of theirs on a date that Mr. Couch had indicated in his very busy schedule were open. So Mrs. Johnston is unemployed, and they usually are hanging out most of the summer at their cabin next to mine, which is a very short distance from where Mr. Couch set my deposition. So knowing he was available on July 15th and July 16th, I set the Johnston's depositions for that date at the same location. It is only then that Mr. Couch contacted me and said, although he's available, he never told me that the Johnstons were available, and therefore it was improper for me to set those dates. So he took my deposition on July 17th, and he had indicated July 15th and July 16th also worked for him. So I set those dates. Mr. Couch had previously complained that I didn't give him 14 days notice. So I made sure that I gave him 14 days notice, and I picked dates available for him. When he complained that he hadn't cleared those dates for the Johnstons and they had conflicts, quote unquote, without stating what the conflicts were, even upon my request, I then offered 14 days that I would be willing to take the Johnstons' depositions, or we could take them the same day that I was set. I've not been obstructionist. I've been trying to get my rights under the court rules to take the depositions of the defendants. That's all. So Mr. Couch refused. He said they were unavailable all 14 days. And the court has those emails. So I set the depositions properly under the court rule. Now we get to this point, and the court maybe doesn't know who to believe, even though I think you've seen the emails. So let's follow the court rules. The most basic, we're still in the 2.100s. To support a contested motion under MCR 2.119, Mr. Couch must present this court with testimony by either affidavit or other sworn testimony that would support his claim that the Johnstons had such a conflict, not only on the date that I set them, but also on the other dates that were offered under the court rule, that they were conflicted to the extent that this court would excuse them failing to show up for the third time for their deposition, once on a date agreed to by counsel. There's just nothing on the record other than counsel statements, which are not evidence, to support a 2.119 motion that would allow this court to find that the Johnstons were so conflicted that they just couldn't show up, and this court subsequently excused them. Your Honor, this has been an extreme pattern of not only passive aggression, but outright aggression and abuse of all of the county and state officials to attack me because they took out a drain system that flooded my house. That's coming, but I would ask the court to require them to support this motion to convince the court that they really truly couldn't make their deposition or any of the other 14 dates offered. Thank you for your patience, Judge.
All right, thank you, Mr. Couch. To your motion, any response?
Just very briefly, Your Honor. This is not the plaintiff's motion to compel discovery. This is the defendant Johnston's motion for a protective order, asking for the court's assistance in setting their depositions on a date that works for everyone. Mr. Riemann eventually did acknowledge to the court that the July 15th and 16th dates, those were open on my calendar, but not for my clients. So when he scheduled their depositions on that date, I told him that they didn't work. And then lastly, he's talked about this habit of my clients not showing up for their depositions. And it's because Mr. Riemann has scheduled them on dates that he knows they're not available. I just want to move forward with discovery. We're asking for the court's assistance to set them, please, either August 21, 22nd, or 23rd, and then he can take their depositions and everyone can move forward.
Okay, so I am viewing this as a motion for protective order. And Mr. Riemann, you may have grounds for a motion to compel discovery, but that motion hasn't been filed as of now and isn't before the court. So I'm analyzing this purely from the standpoint of a motion for protective order. I don't think that that's something that's appropriate at this time. I view motions for protective order as to, as in that court rule as a mechanism for a party to prevent or avoid either irrelevant or unnecessary or harassing discovery requests. or otherwise inappropriate discovery requests. And that's just not what we're dealing with here. And, you know, I addressed the last motion regarding the depositions, but I am absolutely not going to get in the business of being a scheduling clerk for you guys in your depositions and your discovery. I'm not going to insert myself into how the two of you and Mr. Carey, to the extent he's involved in discovery as well, schedule your discovery. I'm not going to have hearings every month to set dates for you guys. I'm just not going to do it. I don't think that's the role of the court, and I don't think it's appropriate, and I think it sets a terrible precedent going forward. So I don't think there's a need for a protective order here. I think the two of you need to work out how you're going to do depositions. And if you can't, and Mr. Couch, your clients don't show up, then Mr. Ryman files a motion to compel, and then we decide whether or not your clients had a reasonable basis to not appear for discovery, or whether they should be compelled and costs and so forth should be ordered. And I can appreciate, you know, you're trying to get ahead of that, but I just don't think the court rules allow for it. And again, I'm not going to get in the business of every month coming back and having you guys give dates and have me decide which dates you're going to have your discovery on. That's just not going to do it. And I don't think it's called for or appropriate under the court rules. So the motion is denied. And Mr. Couch, if you could prepare an order that reflects the ruling of the court today and submit that under the 7-day rule. And that's all I have for today. All parties are free to disconnect at this time.
Thank you.
Hey, Judge,
Yes.
do we have anybody sitting in the waiting room? He's under this name. Because we had some from the earlier, from the front of the court, and I think he's been on there 2.5 hours, he said.
I have somebody under the name Christina Whiteman, and as far as I'm aware, there isn't anybody with that name on my
Okay,
doc.
apparently he was sitting there underneath that one, but we'll just let him know what went on then. Apparently that's who he's logged in under, so, okay.
Yeah, let them know. I mean, if I see Christina Whiteman and I don't have Christina Whiteman on the docket, there would be no reason for me. So whoever it is, they need to start signing in under their name so I know who it is.
Okay, thank you, sir.
You can let them know that. All right, thank you.